This is the fourth in a series of videos prepared by the Office for Dispute Resolution and the Pennsylvania Special Education Hearing Officers to assist parties in understanding and participating in special education due process hearings. After viewing the previous videos, you might be asking yourself, how can I avoid becoming involved in a due process hearing in the first place? Although sometimes a hearing is unavoidable, there are some things that parents and local education agencies, or LEAs, can do to minimize the chances of needing a hearing. Some suggestions will be offered here. If despite your best efforts to resolve the problem you're having a hearing, you may ask, how can I get ready? And what are the expectations during the hearing itself? This video will help you prepare beforehand as well as offer practical advice about being a participant. As in the previous videos, we will use the term school district to refer to any local education agency, including a school district, intermediate unit, or charter school. Avoiding due process, communication, cordiality, and compromise. Two of the best ways parents and school districts can minimize the chances of needing a due process hearing are communication and cordiality. A third way, compromise, will be discussed later on in this video. If you are the parent and feel that your child is not making progress, or if you don't understand some things that the school district is presenting verbally or in writing, voice your questions and concerns earlier rather than later. If you are the school district, keep lines of communication with parents open, responding to their concerns promptly and clearly. Both parents and school districts should use written communication not only to clarify, but to consolidate. For example, follow-up meetings with a letter or email summarizing your understanding of what transpired, especially if any agreements were reached or plans were made. However, it is also important to communicate wisely. Do not engage in long series of emails in an effort to work out a problem. In emails, people tend to be less careful about being concise and clear, may tend to be chatty, and may at times come across as impatient or disrespectful when they are simply tired or hurrying on to their next challenge. Use email or telephone calls to briefly identify a concern. If the concern is complicated and it looks like extended discussion is needed, try to schedule a face-to-face meeting to address the issue. Cordiality is the key in person and in writing. Parents and school districts should keep focused on their partnership in educating the child and treat one another with the respect due their roles. The parent may be the expert when it comes to his or her child, and the school district may be the expert when it comes to special education, but both knowledge sets are necessary to help a child learn. Partners in a child's education should be reasonable and be open to looking at various ways of resolving a problem before resorting to due process. If communication has faltered and cordiality has worn thin, or if the parties are simply agreeing to disagree, a due process hearing may be the only or the best option. Be aware, however, that a due process hearing is an experience that may be stressful. Whether it is the parent or the school district that believes a due process hearing is necessary, the parent should consider whether or not to involve an attorney to represent the family. As noted in a previous video, in Pennsylvania, school districts are required to have an attorney represent them. If you are a parent and intend to retain an attorney, do so early in the process, so that you have someone who knows what he or she is doing from the outset. You should consider retaining an attorney who practices special education law and who knows how courts have interpreted the legal language. A special education attorney will likely know and will likely have worked on many other cases with the attorney representing the school district, and therefore will be in the best position to help resolve the matter without going to a hearing. Parents do prevail at due process hearings when they represent themselves. However, there is a downside to representing yourself. You may not be able to keep an emotional distance that will enable you to think clearly at the hearing. You may not know exactly what the IDEA and its regulations and case law mean, even if you know what they say. And/or you may not be an effective negotiator if settlement discussions are held. If a parent is represented by an attorney, the attorney will work with the school district's attorney to see if the problem can be resolved without a hearing. If the parent does not have an attorney, the school district's attorney will offer to work with the parent to see if an agreement can be reached. Also, remember that if both sides are willing, the Office for Dispute Resolution offers free mediation as well as free resolution meeting facilitation and free IEP and IFSP meeting facilitation. This brings us to compromise. About 85% of all due process hearing requests filed in Pennsylvania do not result in a hearing because the parties reach an amicable agreement either at the mandatory resolution meeting held right after a due process request is filed or during the period leading up to the hearing date. Sometimes hearings even start with a session or two and then settle. Settlements are good things. It is far better to be in control than not to be in control. It is far better to continue forward in the process of educating a child when the parties have come to an amicable agreement than having to request that a hearing officer take the decision-making from your hands. Participating in due process. Once you are actually going to participate in a due process hearing, there are some things to keep in mind about the process that will help make the experience easier and less stressful. Remember, special education due process hearings are formal administrative proceedings that involve litigation. The hearings involve presenting evidence through sworn testimony by witnesses and the introduction of documents. However, formality does not mean stiffness or anger. Do not be upset if your attorney is acting in a friendly manner toward the opposing party's attorney. The hearing officer will likely be cordial to everyone and will be careful to treat both parties and their attorneys the same. There are a relatively small number of special education attorneys practicing in the various sections of the state and relatively few hearing officers. We have all met before, have heard one another present before, and your attorney and opposing counsel may have even done a workshop together before. The outcome of the case is fact-specific, and the hearing officer will base the decision only on the facts of the case and the law as applied to the facts, and not on whom the hearing officer knows better. Dress for the hearing as you would for your job or for a job interview. It indicates respect for the process. Arrange childcare. You never know how long you will have to be at the hearing, and it is very disruptive to the efficient conclusion of the process to have to curtail a hearing day because you didn't prepare to be home late. Do not cry or laugh or show horrified surprise or shake your head vigorously from side to side when someone is testifying. Do not look at a magazine and loudly turn the pages. Do not go through your mail. Do not bring your laptop into the hearing and catch up on your work. All these are extremely distracting to the hearing officer who is trying to listen to and absorb the evidence presented. Testify accurately and truthfully. As a major component of their responsibility to render a decision regarding matters in dispute, hearing officers have the responsibility to judge the credibility of witnesses. Credibility combines the cumulative impression of the data the witness offers and the manner in which the witness presents him or herself. Don't get hurt feelings. Remember that the opposing attorney is just doing his or her job of representing the client in the most effective manner possible, even if part of that process involves attempting to undermine your credibility. Be cool and collected. Hearing officers are not impressed with drama. Do not lecture the other party or the party's attorney during your testimony. Do not raise your voice, and do not stomp from the room. Hearing officers are used to witnesses being a little bit nervous. A little bit nervous is fine. Be focused. When you testify, look at the attorney asking the questions, but look at the hearing officer when you answer. Many witnesses look earnestly at the court reporter as though trying to convince him or her. Do not talk too fast. One warning from the court reporter or the hearing officer to slow down should be enough. Listen. Pay attention to the question and answer what is asked. Do not exaggerate or try to avoid the question by answering a different question that wasn't asked. Give as brief an answer as you can that conveys the information requested. Remember what your mom taught you. Be respectful and courteous to the other party, the hearing officer, and opposing counsel. No one, especially the hearing officer, will be impressed by your sparring with witnesses or opposing counsel. Do not become snippy or surly. Answer all questions and maintain a calm and reasonable demeanor. The best witnesses are those who are good when examined by the opposing party or counsel. It doesn't take much to be good when the attorney is on your side. With the other side, be calm, be truthful, and try not to be defensive. It is what it is, and you did what you did. Final words. In this video, you have learned that communication, cordiality, and compromise can lead to resolving a dispute before a due process hearing is necessary. You have also learned practical ways about how to prepare for and how to conduct yourself during a due process hearing. One final word. After the hearing has ended and the decision is rendered, make every effort to move on. Begin repairing the school-family relationship. Whatever the outcome of the hearing, the focus is still the child.
For more information, please contact the Consult Line or the Office for Dispute Resolution.